gentlemen, the official party is about to enter the hall. Would you please stand?
Ladies and gentlemen, on behalf of the Legal Practitioners Admission Board and the Law Extension Committee of the University of Sydney, can I welcome you here tonight. I especially welcome Professor Webber, who will be introduced later by the Chair of the Extension Committee, Mrs. Cock. The purpose of this occasion is to recognise the achievements of those of our students at law who have completed the academic component of the requirements for admission as legal practitioners of the Supreme Court of New South Wales, and to present them with their diplomas to signify that success. The Board and the Law Extension Committee have operated in partnership for many years now, with the Extension Committee providing the academic instruction required to enable students to sit the Board's examinations. And it is for that reason that we're able to hold this ceremony tonight in this wonderful great hall. We are proud of you students who are here to receive your diplomas tonight, and glad at this chance to say so. No one suggests that the course which you have completed is perfect, but we are satisfied that it is a good one and a challenging one, and that you are to be congratulated on completing it. Particularly, of course, as we are aware that many of you are holding quite onerous jobs at the same time as studying for this course. So it's appropriate to recognise your achievements and appropriate to recognise the presence of your family and friends who in one way or another, whether by sacrifice, money, love, encouragement, or all four, or some more, have helped to get you here tonight. The board is, of course, an admission board, and I suppose if it is stuck strictly to its task, it would be interested in educating only those who wish to practice as barristers or solicitors. And for that reason, the course is quite a practical one. But people commence studies in law for many reasons, most of which we ought to encourage. Because they want to reform the world, because one of their parents or one of their friends is a lawyer, because they think, quite wrongly in most cases, that they'll make a lot of money out of it, because they wish to assist others weaker than they are, and perhaps because they think they have the Chief Justice's wig in their saddlebags. Our hope is that when our students finish the course, that they will understand the absolute requirement of a proper system of justice for a democratic, civilised society, and that in their careers in the law they will do their part as lawyers to maintain such a society and enjoy their work in doing so. And so to those who receive their diplomas tonight, well done, and please keep going. And now we will embark on a presentation of the diplomas.
Your Honour, I have pleasure in presenting to you the following persons who, having completed the prescribed tuition and having passed the prescribed examinations, have fulfilled the requirements for the award of the Diploma in Law. Michelle Carmen Allard. Rudy Igor Angulo. Angeline Anthony. Deborah Louise Orkiniki. Caroline Badoui. Mary Louise Battalana. Philip Sean Blackwell. Neil James Blount. Catherine Louise Bray. George Breton. Stephen Michael Bullivant. Louise Elaine Burton. Gregory Butler. Joseph Calabresi. Rebecca Elizabeth Charnock. Ira Christou. Liesl Ann Clubb. Leslie Yvette Coney. Helda Pereira Costa. Peter Cramp. Sharon Eileen Croak. William Daskalopoulos. Gerardo Delicio. Peter James DeMattia. Sandra Donardi. Christopher John Dibb. Jeremy Paul Donoghue. Michelle Louise Duncan. Carl Faulkner Dunn. Cameron James Edwards. David Matthew Farrer. Rita Antoinette Fisher. Peter Thomas Fitzpatrick. Stephen Forbes. Sarah Gowdry. Lily Gestakowska. Jane Marianne Glowry. Andrew James Goddard. Natalia Colleen Guzek. Paul Grant. David Hewitson. Sean Andrew Hughes. Ron Hoipo Hui. Mireia Jane Highland. Emma Louise Kierans. Peter David Christopherson. Despina Latsidis. Clarence Chi Chu Young. Julia Nina Lever. Monique Rose Levis. Paul Charles Lloyd. Stephen Mark Lurie. Brian Gilbert Lutton. Peter Michael McGee. Sally Danielle McCaskill. Michael Devlin McCrudden. Peter James McLaughlin. Donald Cameron McLennan. Jeannie Grace Michelson. Robin Ann Mitchell. Scott Crawford Maloney. Scott Ronald Monk. Susan Amanda Morgan. Patricia Teresa Murphy. Siobhan Isabella Murray. Kylie Nascone. Clint Mercer. Teresa Margaret Nielsen. Ralph Kiwa Nolden. John Patrick O'Byrne. Caroline Ann O'Hare. Philip James O'Hearn. Marzena Maria Olick. Rosa Onotaro. Anthony Neville Parsons. Kim Narelle Pennings. Carrie Nicole Peterson. Vanessa Robin Rees. Malcolm John Lawrence Rich. Richard Jolyon Roden. Anna Rowans Fisher. Freya Yorgini Salvadurai. Alan James David Sharp. John Leslie Sutton. David Kevin Thomas. Martin Anthony Thorne. Richard Joseph Craig Eagle. Stephen James Turner. Amanda Louise Wales. Catherine Julie Winneray. Angela Louise Witten. James Sterling White. James Andrew Wilson. James Anthony Wiseman. And, Your Honour, Roslyn Joan Hicks.
Justice Windier, members of the Legal Practitioners Admission Board, ladies and gentlemen. On behalf of the Law Extension Committee, I would like to add my congratulations and the congratulations of all members of the committee and of the Director to all of those who have successfully negotiated their way through the examinations of the Legal Practitioners Admission Board and are here tonight and have received their diplomas. Congratulations to all of you. I know it is very, very well deserved. We are very aware of the many difficulties that many of you have had to overcome during your time in the course, and we salute you. It is with great pleasure that I introduce the Dean of the Faculty of Law at the University of Sydney, who has agreed tonight to deliver the occasional address. Professor Jeremy Webber holds various academic accolades. He first took a Bachelor of Arts with honours in Political Science at the University of British Columbia. He holds degrees in the Common Law, LLB, and the Civil Law, BCL, from McGill University, where he was a medalist and won many prizes. He took a Master of Laws at Osgoode Hall Law School at York University in Toronto, and he was then awarded the Viscount Bennett Fellowship of the Canadian Bar Association at postgraduate level. From 1984 to 1986, he practised with a Vancouver litigation firm, McAlpine and Hoodo. He consulted over the years with many other firms for the Ontario Law Reform Commission, for the Canadian Department of Justice, and the Canadian Royal Commission on Aboriginal Peoples. He is a frequent commentator on constitutional, Aboriginal and administration of justice issues in the Canadian context. He taught for 11 years at McGill University, where he also served as Associate Dean, Studies and Research from 1994 to 1997. Professor Webber has published widely in English and French in the fields of labour law, Canadian legal history, Aboriginal rights, constitutional law and legal theory. His early work was on the history of Canadian labour law, including comparisons to the history of industrial arbitration in New Zealand and Australia. More recently, his work has been predominantly within the fields of Aboriginal rights and constitutional law. In 1994, his book, Reimagining Canada, Language, Culture, Community and the Canadian Constitution, was named a Choice Outstanding Academic Book and was shortlisted for the Harold Adams Innes Scholarly Book Prize of the Social Science Federation of Canada. Professor Webber has, in addition to his Canadian origins and long service in Canada, had a long association with Australia. Having first spent 8 months here in 1976-7, during which time he worked for a mining company in central New South Wales, and having spent a sabbatical year as visiting scholar at the University of New South Wales in 1993 to 94, and having visited Australia to present papers, and sometimes also for pleasure on many occasions. In 1980 he proved what the pleasure was, I think, and married an Australian. He has published on Australian topics, especially in the field of Aboriginal rights, and in particular I refer to his article, The Jurisprudence of Regret, The Search for Standards of Justice in Mabo, in the Sydney Law Review in 1995. He expects that in the future his work will be primarily within the fields of Australian constitutional law, comparative constitutional law and legal theory, all areas in which no doubt he finds that there is plenty yet to do. As an ex officio member, being Dean of the Law School, of the Law Extension Committee, and with other members of the law school academic staff, he does provide advice and counsel and assists the Law Extension Committee and the Director to articulate and maintain its mission of sound academic standards in the education which it provides to protect prospective legal practitioners. And we are very, very honoured indeed that Professor Webber has agreed to address us tonight. Thank you.
Thank you very much. I'm delighted and honoured to be with you this evening to congratulate all of you on your remarkable accomplishment in obtaining your diplomas. The Law Extension Committee is not an easy route to a legal qualification. A great many of you have worked full-time in your regular jobs, studying in the evening, in order to come to this point. Several of you live outside Sydney and have therefore studied at a distance. All of you have studied in a program that places a premium on your persistence and capacity for individual effort. The diplomas which you have received are a tribute to your commitment and consistency. Your families, spouses, and supporters here tonight must be very, very proud of you. I am also very impressed at the range of backgrounds from which you come and the diversity of aspirations which you harbor. I know that you will draw upon that breadth of experience in the purposes to which you devote your legal training, and it is to that road ahead, to those purposes, that I wish to direct my remarks this evening. I began my academic career as a legal historian. At the time that I was working in the field, in the mid-1980s, a principal focus of research was the development of the legal profession in 19th century Anglo-American jurisdictions, certainly the United Kingdom, but even more the United States and Canada. There was less attention to those themes in the Australian context, but I imagine that many of the conclusions hold true here as well. One of the remarkable conclusions of that research concerned the vision of lawyers' social role held in those societies during that period. We have tended in recent years to embrace, implicitly if not explicitly, a sense of law as a business like many other businesses. One should behave honorably, perhaps, but so must one behave honorably in many walks of life. Essentially, we have tended to slip towards the view that law is simply about the provision of services in the marketplace, in much the same way as accountants, dentists, management consultants, or public relations people provide very valuable services. That was not at all the vision of the lawyer's role in the 19th century. Or at least the useful provision of services was grafted onto a more demanding vision. I want to explore that vision in this talk, not because I want to impress you with the nobility of the legal profession, or simply decry the departure of the profession from a conservative ideal in the past. Rather, I want to emphasize that role because I believe it is a consequence of the special kind of knowledge that we lawyers possess, and the kinds of tasks that are demanded of us. If we want to use those abilities as they should be used, if we want to justify the considerable influence that our profession gives us, if we want to perform our functions as lawyers in the most effective fashion, I believe we should see clearly that there is more than simply the provision of services for a great deal of money about being a lawyer. Thus, what I want to address this evening are first, this broader vision of the role of the legal profession, and second, the implications of that vision as the foundation for lawyers' ethical conduct, indeed as the foundation for the way in which we approach our entire professional lives. So what were those broader social roles of the legal profession? One clue is provided by a feature that is still very much with us: the disproportionate role of lawyers in the business of government. It comes as no surprise to observe that lawyers constitute a large proportion of our politicians. In fact, during the 19th century, the role of lawyers in government was not confined to simply running for and holding office. Lawyers who were in private practice often had, as one of their fundamental roles, intensive involvement in the very drafting of legislation affecting their clients' interests. In much the same way as today's lawyers draft contracts, they were engaged in drafting laws. At a time when many ventures, the building of canals, railways, involved a combination of public and private support, lawyers frequently ended up in management roles, serving as directors, as of course they often do in today's corporations. In fact, this engagement in the business of government was not unprecedented. It was not solely a product of the industrial age, in which legislation became as important as contract, although it wasn't indeed affected by both those things. Lawyers had long fulfilled a role as intermediaries between the state and their society. That is patent in the civil law profession of the notary, in which this special class of lawyers acted for both parties, not just one, in land transactions, could produce specially authenticated documents, and kept the official deposits of documents dealing with land transactions in the locality. Indeed, before the advent of modern registration systems, solicitors in common law countries were similarly the privileged custodians of records of land ownership, mortgages, and so on. Lawyers in private practice still exercise a much more active public role than we often recognize. When I was practicing, our firm often represented clients' interests before local councils. We often made submissions to commissions of inquiry and to parliamentary committees, and I imagine you will be doing that as well. And of course, there are a number of elements at the very heart of legal practice that continue to emphasize our truly public obligations, such as the notion that lawyers are officers of the court. Even in their services to private clients, it is a mistake to think of lawyers as though they were simply providing from time to time such isolated services as the preparation of a will or a contract or representation in criminal proceedings. Lawyers have always, and still today, participated in a longer-term and more constructive relationship with a great many of their clients. They structure the legal affairs generally of their clients, rather than simply dealing with isolated matters. They attempt to ensure that the general conduct of the client's businesses conforms to legal requirements and, more than that, takes proper advantage of the opportunities provided by the legal environment. Quite commonly, this draws lawyers into a more general concern with the conduct of their clients' business affairs. In the 19th century, it was very common for lawyers to engage actively in the search for investors in commercial enterprises, acting essentially as investment brokers, and the organization of the capital structure of the companies to accommodate that investment. Lawyers still commonly end up serving on boards of directors in ways that combine the roles of legal and business advice. A good number actually cross over to full-time managerial roles. Solicitors, in their advice to clients on wills and estates, frequently end up advising their clients on charitable organizations that their clients may wish to support, and frequently are named trustees and executors. The lawyer's role has therefore always extended beyond charging a certain amount for a will, another amount for a conveyance, or a certain amount per hour for representation in court. It has always pulled lawyers into a broader concern with the general affairs of their clients and how those affairs interact with the existing structure of law and where that structure might be moving or be made to move in the future. What gives lawyers this special role? I believe it has much to do with the privileged role of lawyers as experts not on the particular detail of the law, but more generally on the interface between the structure of government regulation and the individual. Individual initiative in a complex society depends, for its success, on the coordination ideally achieved through legal regulation. We often praise individual effort without recognizing the contribution of that framework. Now, I don't want to minimize individual effort, and I know, and indeed just praised, the effort that you've gone to in order to come to this point. But the success of that kind of effort requires the stable, predictable, peaceable societies that we all too often take for granted. A couple of my colleagues work on issues with respect to the establishment of the rule of law in Eastern Europe, where those things that we take so much for granted certainly were not present, and indeed have to be established by conscious effort, and one sees very much the value of that kind of framework within which we work. And lawyers are expert in dealing with that interaction of individual aims and governmental regulation. I know that when I first came to study law, what struck me as most distinctive about law was the practical discipline it imposed. One could not be content with simply leaving one's aims at a broad level of generality, with simply asserting what would be philosophically best. One had to concentrate specifically on how those objectives, how those aims, could be translated into very specific measures, very specific institutions that could operate day by day, drawing upon the energies of people as it found them, without requiring that they be angels or even personal experts in social ordering. Law is all about bringing general principles, general objectives, down to specific, workable, institutional form. I apologize for this long discussion of what might appear straightforward, the role of the lawyer, but I believe it's fundamentally important to realize that that role is, and always has been, more than simply executing that mortgage or speaking for this client. Lawyers are especially responsible for the development of the law as a mechanism of social coordination. In the terminology of one of my predecessors as professor in the Faculty of Law, Julia Stone, in whose honor we are currently conducting a campaign to establish the Julia Stone Institute of Jurisprudence, lawyers are responsible for the development of law as an effective and just means of social control. And it is that broader knowledge and that broader expertise that lies behind our special responsibility, the special ethical obligations of lawyers. When you learned about legal ethics, the chances are that you learned about it as a series of do's and don'ts. What a lawyer is permitted to do versus what a lawyer must resolutely avoid. And such rules are, of course, extremely useful in giving guidance as to what conduct lawyers should follow. But I believe it's a mistake, and indeed an impossibility, to attempt to reduce ethics to a set of rules. A system of ethics is unusual in that it is not simply a set of isolated commands as to what can and cannot be done. Rather, ethics forces us to look carefully at social roles and to think about the standards of conduct and the constraints that are inherent in those roles. Ethics is very much more about the essential relationship and the types of conduct that should flow from that relationship, the spirit in which that relationship should be pursued, rather than highly specific injunctions. In order to understand what ethics requires, then, it's crucial to reflect upon the nature of that social role. And that is one good reason why it is worth realizing that lawyers are more than simple sellers of services. Their privileged knowledge of the law and how it relates to action within society, their role in working with how individual aims should be reconciled with governmental ordering, all impose special responsibilities to pursue those obligations conscientiously, to realize when additional expertise is needed and to seek that expertise where it can be found, and certainly to ensure that one does not take advantage of one's privileged knowledge in order to misserve one's clients. And one also has significant responsibilities of fidelity to law, so that in the business of reconciling individual aims to social purposes, one does not subvert the latter. For of course, the effective achievement of individual ends in complex societies requires a viable and workable framework of social ordering. Now, one does not always get that broader vision in a course of legal education. Often that kind of course seems to be all rules. And even if the broader conception is present in the teaching, it isn't always received. People often think of law as being about rules. And so when they study law, that is often all they see. The other stuff may seem like interesting perspective, but with little practical relevance. But it does have practical relevance, both in describing the kinds of roles you will be fulfilling in the very near future and the ethical obligations that come with those roles. If you're alive to those obligations and fulfill them, you will make much better use of the education you've had. You will be much better lawyers, even in the most technical sense, and you will have fulfilled the promise that is so evident in this room tonight. One of the remarkable things about the legal profession is how continual learning is written right into it. We are constantly encountering new situations, new problems, new areas of business, new demands of human activity, and are forced to understand them and understand how the law should be best interpreted to fit them. The very process of analyzing a brief or structuring a proposed transaction requires that one attempt to judge what the law means in this particular and often in its detail unprecedented circumstance. And often at a broader level, our career takes us into areas of law or into ways of working with law that we never expected to encounter. I have no doubt that legal practice will expand your vision of what the role of the lawyer is all about, as it did mine, and that your career will be one of further learning, continual education. The persistence, industriousness, and commitment that you have shown to get here is a sign that you will succeed and succeed well. You have accomplished a great deal. I'm delighted to be able to congratulate you, and I salute that accomplishment. Thank you very much.
Ladies and gentlemen, the formal proceedings have now concluded. A light refreshment is to be served nearby in the University Club, to which you are all cordially invited. The President of the Legal Practitioners Admission Board, the Chairperson of the Law Extension Committee, and other members of the official party, followed by those who have been presented with their diplomas tonight, are about to leave the hall. Would you please stand?